I've got a presentation. I will share my screen so we can see that. Feel free, as Tamara said, to give us any questions that you've got, and we will try to answer those as best we can. So as you consider reopening your business in the midst of this pandemic, and I know it seems like we've been in it a long time, and it may seem like we're near the end. I'm definitely not a medical doctor. I'm not an epidemiologist. I don't know those questions, but it still seems like we are in the midst of it. And you may be concerned about your business's liability with respect to your employees, with respect to your customers and clients, or even with respect to other businesses that you are involved with. So I hope that we are able to discuss today some things to give you some guidance on what sort of risks are out there and how best to attempt to mitigate those risks. Right now, as everybody knows, the act of just living comes with increased risks. And so we as a society, primarily through our legislative branch and our court systems, we're going to have to determine the best way to allocate those risks. Do we place more of a burden on our businesses to make their premises safe and secure for employees and customers? Are we going to place more of a burden on individuals to ensure their own safety? And likely it's going to be somewhere in between the two of those. So the law often takes a long time to catch up with cultural and societal changes. And since this pandemic is so new and unprecedented, I think it will be a while before we really start to understand the impact it's having on our businesses. So what I won't be doing is giving any sort of magic bullet on avoiding lawsuits. I can't do that. I tell people all the time, all we can do is reduce the risk that it will happen and ensure that we're taking steps so that if a lawsuit is filed, we know we've done everything we can to avoid it. I'm going to talk about some reasonably foreseeable scenarios and discuss a little bit of the legal framework, and then talk about some other things that you might do to help make lawsuits less likely. Really, this is more about education and best practices than eliminating all risk. Also, every business is going to be unique, and they're going to face unique challenges with respect to your workforce and with respect to your customers. And so the information I'll give here is general. I will get into some specific examples, but like I said, the main information is going to be very general. And just one more time, if you have any questions, you can put them in the chat. You can also reach out to me after the session is over. I have my information on the website. Tamara has it. You know where to find us here in Fulton, and happy to set up some time to chat with you about your specific issues. So I'm going to address the three sort of main scenarios where I see the biggest risks with respect to your business and any liability. And those three main scenarios are with your customers, with your employees, with your customers or clients, and then with other businesses. So when we're talking about employees, we're talking about things like liability to the employees if they contract or quarantine for COVID-19, potentially contracting it at work. Things like failing to provide correct PPE, failing to train on how to use that, failing to implement social distancing. We're also talking about employees issues when we're talking about the expanded leave requirements under the Families First Coronavirus Relief Act, the FFCRA, and what potential issues are there. So then when we move on to customers and clients, again, we're talking about things like clients or customers contracting COVID if they're in our places of employment and places of business. Then on the other side, we're also talking about things like refunds. Is a customer entitled to a refund if they didn't get the good or service that they were seeking because you were unable to provide that? And then thirdly, we have other businesses, and this is more of a scenario where you have agreements with other businesses to provide goods or services to your business, or on the flip side, your business is providing things to others, And you're unable to do that because you're shut down, you don't have employees, you aren't able to manufacture your goods because you're not able to get what you need because of the pandemic. So we'll look at that, look at a few scenarios there. So just real briefly, and this is the legal stuff that is exciting to me and nobody else, but we'll go through it anyway. So the types of claims that somebody might bring, really when we're talking about tort claims, these are civil liability between two parties to redress monetary damages. You may have heard of this term negligence. It's kind of a broad term. We also have contract claims. So these are things like your refunds. These are things your business versus another business. And then of course, you have your statutory claims. So those are our written laws, both state and federal. Those would be things like workers' compensation, unemployment compensation, FMLA and FFCRA, where they're specifically spelled out in statute about how those claims or what requirements are there and then how claims are brought under those statutes. So just, again, really briefly, negligent conduct. When we're talking about negligence, this is conduct that falls below a standard established by the law for protection of others against unreasonable harm. So that's a lot of words there. I mean, it can be boiled down to basically one word, and that's reasonable. Have you been reasonable in how you've conducted yourself and your business? There are these elements. Do you have a duty to protect against unreasonable risks? You know, did you fail to comply with that duty? Was your conduct the cause of the injuries or the damages? And then what were the actual damages? So we're talking about contracts. This one's a little more straightforward, and a lot of you are familiar with these because you do this day in and day out. You know, do you have a valid contract? Did you perform, or did the other person perform? Was there a breach? And then what are the damages? Of course, in both of these, we have the potential for defenses. Did, you know, the failure of you to perform your contract, was that because it was impossible? That's a defense to a breach of contract action. We'll talk a little bit more about those as we get into some specific examples. But the first category we'll dig into a little bit is with your employees. Now, again, the concern here regarding liability, you know, right now, the most immediate concern is going to be, am I as a business owner responsible if one of my employees comes down with COVID-19 and they claim it happened at work? So the answer is pretty complicated, but here are some things to consider. So in Missouri, as an employer, you have certain duties regarding the safety of your workforce. And you can see these here on the screen. You have a duty to provide a safe workplace, to provide safe equipment in the workplace, to warn employees of dangers that they're not reasonably to be expected to be aware of. You have to provide a sufficient number of competent fellow employees, and you have to promulgate and enforce rules governing employee conduct and safety. And so if you think about each of these within the framework of a pandemic or of COVID-19, you could see where at any one of these levels, you could have a problem with your workplace. You know, are you providing a safe workplace? In this situation, we're looking at things like implementing appropriate social distancing precautions. You know, are your employees able to work 6 feet apart? This might even be things like telework. Are they able to work remotely? And do they have the supports that they need to do that? You can see where, you know, providing a sufficient number of employees, you know, do you have a large chunk of your workforce out because they're sick or because they're caring for someone who is sick? And so then you're not able to provide a safe workspace for the people that are there. And then of course, the rules governing employee conduct to enhance safety, those are, you know, what we've been hearing about all the time in terms of PPE and training to use the PPE. How, you know, how often do we change masks, and how, you know, do we get one a day? Do we get one a week? we're hearing a lot about that. One of the things that's been in the news recently, and in fact was just on the news this morning, was about the requirement of meatpacking plants to go back to work. They're mandated to go back to work. The employees, though, are having issues, and what they feel are, lack of sufficient precautions taken to ensure, to eliminate or reduce the risk of transmission of COVID. So those are the sorts of things that we're talking about when we're talking about safety. And, an employer can't get out of these things by trying to push them off on other employees or even third-party contractors. The employer is going to be responsible if they don't provide these basic safety measures. So in thinking about some potential scenarios, again, the biggest one, you reopen now, and one of your employees comes down with COVID-19. They claim it was at work. Are you responsible? Anybody want to take a shot at that one? Well, in true lawyerly fashion, I will say it depends. So I think the answer to this question is going to depend a lot upon what type of business you have, how often you're having, the public come into your business. It's also going to depend on what types of precautions that you took to reduce the spread of COVID-19. Here, let's say you own a retail business or a restaurant and you told your employees to come back or they'd be fired. I think that right there is one red flag that we need to be cautious of when we're putting people to that sort of choice at this period of time. But let's say then you failed to provide proper PPE, you didn't train them on appropriate social distancing with other employees or customers, you didn't urge them to stay home when they were sick, have extra hand washing and sanitizing stations, didn't do extra cleaning, basically didn't do anything. If the employee can show, if they can pinpoint that in fact they, were exposed in the workplace and you didn't do any of that, then they potentially have a claim. And I think there are two ways that this claim is brought. One way is under a workers' compensation claim. The issue here is going to be whether or not COVID-19 is considered an occupational disease. And it would be for the employee to prove, and they would have to show two things about an occupational disease. One, whether there was an exposure to the disease that was greater than or different from that which affects the public generally. And again, that's going to be pretty difficult. And two, whether there was a recognizable link between the disease and some distinctive feature of the employee's job. So you can see that, because we still have relatively little information about how this is spreading, how many asymptomatic carriers are out there, whether or not it hangs in the air for 20 seconds or 10 seconds, whether or not 6 feet is actually long enough. You can see all of these things are going to create kind of a mess in trying to prove, yep, I know that I caught that at the job. I think it would have to be something along the lines of, I didn't go anywhere for 3 weeks, and then I came back to work and all of a sudden I was exposed. So you can see those are tricky questions. Some states have actually imposed presumptions in workers' comp statutes that say, we're gonna presume that if you catch COVID-19, that it is an occupational disease and you did get it at work. In Missouri, we actually have one of these for first responders. So the emergency rule says, look, if you're a first responder and you get COVID-19 or you're quarantined, presumptive positive test, something like that, we're going to presume that you caught it, arising out of and in the course of your employment, and thus you would, potentially be covered under workers' comp. And there's some caveats to that. I actually don't think we're probably going to see from our legislature additional presumptions, for other types of businesses, but that's something that could happen. And so that's something to be aware of out there that the legislature could decide they want to do. So the other way that we get at these claims So workers' comp is one way. And then the other way is just a pure negligence, what we talked about before. Did you act in a reasonable manner? Did you act as a reasonable business would under the same or similar circumstances? And here again, you can understand that all the different elements, you do have a duty to provide a safe workplace, but again, that causation question, that's going to be a big one. How did they prove that they caught COVID-19 in the workplace? So going back and talking a little bit more about another scenario that we might see, and in fact, I think this one may be more common even than contracting COVID-19, just because of the issue with causation. That's going to be hard to prove, is when you have employees who are wanting to take the more expanded leave under FMLA or the FFCRA. So let's assume you reopen your business, but one of your employees needs to take leave because her kids are still out of school and she doesn't have another care provider. Under the FFCRA, there are provisions allowing for an expanded leave and even paid leave in some circumstances. So let's say you fire her for taking that leave and for requesting it, and she sues you for a wrongful discharge. One of the things that, a lot of employers in this state, and it is very true that we are an at-will employment state, meaning that you don't have an obligation to keep your employees. This situation is different, however, in that federal law explicitly prohibits a business from firing, discharging, demoting, or even retaliating against an employee for asserting their rights under these new laws. So you're in hot water here. I think you probably are liable. The Act provides some specific penalties if you do this sort of thing. And that's really beyond the scope of what we'll talk about here today. If you are interested in that more specific information, feel free to reach out. We can get that to you. And again, it is complicated because sometimes the employee is entitled to, full pay. Sometimes they're entitled to only 2/3 of their pay. And so, we actually had a situation come up a couple of weeks ago with a client of ours. They had shut down their business and furloughed some employees. Well, when they opened back up, one of the furloughed employees put in an application for this extended leave, this paid leave, and come to find out that due to the timing of when the law took effect and how the furlough works, this employee was not actually entitled to take that paid leave. And so there are some really specific requirements. And if you have, like I said, if you have more specific questions, we can work through those with your particular business or a particular situation that you're facing. In that situation, the Department of Labor was very active in pursuing the business when it seemed like there was a problem with the business not allowing the leave. So just be very aware that, the Department of Labor, they're on it when it comes to these leave policies and making sure the businesses are complying. So the other part of that too was the furloughed employees, or the employees that were laid off, would qualify for unemployment compensation. So it's not like there's no benefits available to them. It's not like they're just out of luck. They still would potentially qualify for the unemployment. And so, it'd be good to direct them in that route. Some of these things I've been talking about are extreme, and I don't think it would be very hard for someone to say, yeah, in that very extreme case where nobody did anything, that was bad. They should be held responsible. So a lot of times these cases are happening on a continuum where you have some really bad actors and they're doing things that nobody would condone, and then you have people that are doing everything that they can. And so you can see that the answers to those questions, am I liable, on the extremes are easier questions. The harder questions are going to be the ones that are in the middles. You did some stuff for your business, but did you do everything that you could have done? Now, the law doesn't require you to implement every single, guidance, every single social distancing measure that is out there. But what the law does require is that you act reasonably and that you act within basically a range of what businesses like yours are doing. I think one of the things, and I'll come back to this a lot, is as a business owner, you have to educate yourself on what these requirements are. You have a great resource in Tamara and the chamber staff, and so utilize them as much as you can. There's a lot of good resources even out there, online at the Missouri Chamber of Commerce on returning to work, and even at the federal level on these guidance on these new leave policies. So educate yourself and make sure you're knowing what your responsibilities are. So I think the same goes in terms of cases on a continuum for the leave policies and whether or not you're going to be responsible to your employees for not doing what you should. Did you educate yourself? Did you give your employees timely and accurate information about these leave policies? Or did you make it more difficult for them to apply or to get information? And courts are going to look at all those things and determining whether or not you're going to be liable to your employees for that. So in case anybody's wondering if any of these suits have been filed yet, the answer is yes. They have. I haven't found any Missouri cases specifically on point. Doesn't mean they're not out there. I haven't found them. But in Illinois, there was an employee who contracted COVID-19 and died, and her family is suing Walmart, her employer, claiming that she contracted it from working in the store. In Florida, there has been a class action suit against a cruise line for failing to follow safety precautions such as masks and other social distancing. And then in South Carolina, there is a case of wrongful discharge for a person who claims she was fired after requesting the paid leave under the FFCRA. So, these are not hypothetical. They're really happening. Just a word of caution, everybody. We have jokes about lawyers and things like that, and I don't like to kind of talk bad, but there are people who are opportunistic and they're looking for chances to take advantage. And then there are people who are just trying to protect workers and protect employees. And sometimes it's hard to tell which is which, but I think we'll see more as time goes on. So the next thing we have is customers and clients. And actually there was a question. I don't know if we want to answer that. I'll go ahead and take it now. So it's what liability do nonprofit organizations and congregations face as they reopen? So the issues are going to be the same, relatively speaking, for nonprofit organizations and churches. I think they have, I didn't look at this specifically, and so, I'm happy to give any general information or more specific, but they're going to have some of the same duties as employers that for-profit businesses do in terms of keeping their employees safe and providing those. It's just like, a nonprofit organization, if it otherwise meets the requirements, has to have workers' comp insurance for their employees, and they have to make sure they're following other guidelines for leave, and things of that nature. Same things with churches. They don't necessarily get a free pass for failing to keep their employees safe and, keep people in their congregation from, being exposed to unreasonable risks. So I hope that answers part of your question. We can come back to some more specific things when we're talking about clients, because I think for congregations, most of the time we're going to be talking about, congregants and people coming back to worship. And I would consider them more kind of in the client category. So we can come back to that in a moment. So I'm going to get back to my PowerPoint here, if you'll bear with me. I apologize for this. Well, let's talk. I will see if I can get that back on there. If we can then move on to really the customers and client scenarios. Here we're talking again about what happens when one of my customers or one of my clients contracts COVID-19 and they claim that it was something that I did at my business because they patronized my business and wanted to sue me for that. I think that, again, it's going to depend a lot on the specific situation. Let's take something that I don't know a lot of people had some concern about, and it would be, what if one of your employees comes to work sick and, like they're coughing or they're visibly ill. You didn't notice it because you were doing other things and nobody mentioned it to you, or maybe somebody did. And then you find out later that they test positive for COVID-19. What's your responsibility? What's your liability? Can then a customer who claims they contracted it at your workplace sue you for that? I think we're talking about some of the same sorts of, analysis when we're talking about employees. What sort of precautions did you take? Did you tell people to stay home when they were sick? Did you, when you found out that an employee was sick, did you attempt to, basically quarantine them until such time as they could leave? Did you help protect the other employees and the customers by giving accurate and timely information about that? Were you transparent? Did you then implement, additional sanitizing requirements? And, this is a scenario that would have happened maybe before we're getting into some of these, major shutdowns where there were some things still open. I think, we're still kind of up in the air on whether or not these things are actually going to come to fruition. I haven't come across any lawsuits filed by customers, alleging that they contracted COVID-19 at a business establishment, but it doesn't mean that, that there are not people out there who are considering that. There's another thing when we're talking about reopening that could be a concern for some, and this would be, again, you reopen your business and a customer comes in and then they claim they contracted COVID-19. Well, they could, again, have all of those same questions about, how can you prove that you caught it here? And, do we know what precautions did the business take to keep its customers reasonably safe? There's another question I have that sort of came up to me. Is there any sort of issue with the misrepresentation? Did the business represent that they were open and thus safe to be open? And so then the customer came in and they were exposed, in an unreasonable manner. So I think those questions, again, we haven't seen them, but I don't think they're far off. We have, attorneys are creative and we will find ways to, to pursue claims. More often than not, we are telling people, not to file claims because litigation is time consuming and expensive. And most of the time, you're not going to get the $1 million settlement. These are not the ones that we're looking at. The class action lawsuits against the larger employees, those are the ones with the major funds involved, but it's still an issue. It is still a risk for your business, and it is something that you want to be aware of to try and reduce the risk that happens to you. So I think, those claims are going to be hard to bring because I think what a customer is going to have to show is basically an extreme lack of precautions taken, basically none. And then that person had not been exposed to the public in any fashion, for several weeks, and then came into your business first thing and when it was exposed there. So again, very, very specific scenarios about what happened and when and who knew what when, all of those things make the cases a little harder to bring. I think the second biggest scenario, and we do see claims being filed against businesses for refunds or returns when, let's say their failure to give customers the good or the service that they paid for because the business wasn't open. Or customers canceled plans but didn't get a refund. We're seeing, class action lawsuits against airlines right now for failing to give cash refunds. We're seeing some against, ski resorts for things like failure to give refunds. So, here, if you have a person who pays a $50 deposit to reserve a room in your restaurant for a party that they're having, let's say they're going to have it on April 10th, and typically that deposit would be non-refundable. Assume you close on April the 6th because of the stay-at-home order and the CDC guidelines and everything like that. And then the person asks for a refund because they're not able to have their party because you closed. So do you have a legal obligation to give them a refund? If you told them, this refund is this deposit is non-refundable, maybe there was another deposit that was refundable or something. And so, it's probably going to depend on whether or not a court would find that you were being, reasonable or unreasonable, and what the terms of your agreement were with them. This is a contract. This is a contract question. Now, here's the second part of these questions that come with consumers and even with employees. But, should you give them a refund of their money? My opinion is yes. I do not think it is worth damaging your business, because this person's going to go out and post on Fulton Good, Bad, and Ugly about, whether or not you gave them a refund, and you certainly want it to be on the good and not on the bad or the ugly side about how that worked out. I think those things are, are going to be really important for the continuation of your business. Now, there may be a different question when you're talking about, you're a party rental venue, and that's your primary business. And so now you're having to cancel all events. So, those are the really tough questions that, it's going to take a while to get sorted out in the courts. And the best thing, again, we can do is try to be reasonable with people, educate yourself on what you're doing, talk to your customers, ask them about, continuing to support you during this time if you're not opening. Or even if you are, and you're not doing some of these things, hey, would you, can I keep your $50, but we'll schedule you for a later date, or we'll give you, there's some things you can do to help keep those customers happy and coming back and talking good about your business in the community. So, we have things like gyms or health clubs, things like that you pay for on like a subscription or a monthly basis. Again, those questions of, if you're not open, do you give them a refund? I think that also goes, is a good conversation to have about, what are the benefits that you're providing your customers if you're not able to be open? Are there other things you can do? Can you do training by Zoom? Can you provide them some additional workouts or, support for their home exercise regimens, that they might continue to support you even though you're not open. The other part of this, I think, is going to potentially turn on whether or not your business was forced to shut down or whether it was only a suggestion. Because so in Missouri, we didn't have, a very strict lockdown. We could still have businesses open. And if they're, doing social distancing appropriately, a lot of businesses just decided to close down because it was easier or they didn't have the workforce. But, some of these questions may turn on, was it really impossible for you to provide the service? Or was it inconvenient? And those questions are up in the air. We had one where a client was selling her home and was in a real estate contract and was supposed to close in the middle of all this. She was immunocompromised. And so she did not want to be going into other people's homes looking for another place to buy, while all this was going on. And so we had to work with the buyer. Eventually we got it resolved to where it was negotiated that they're going to, extend the closing date. But, some of those questions again turn on, was it impossible for her to perform? Probably not. But, we are certainly glad that we were able to do some negotiating and find a reasonable solution for everyone. Some contracts too will have what we call force majeure clauses that state something like, in the event of an act of God or an act of war, something that is outside either of the parties' control, then here's what's going to happen with these contracts. And so, that's something to just look at to see if that would apply to you. And then you'd look at, are we under a force majeure situation? Probably. And then what do you do from there? And so again, talking to your contracting parties, to make sure you can come up with reasonable solutions. And if it doesn't look like it's going that way, then come see us and we can talk through what those options are as well. We'd be happy to talk through more specific situations. Some of these, as we've talked about, are really more what you should do rather than what you're legally obligated to do. There's a distinction there oftentimes. So again, be reasonable and be smart and educate yourself. So somebody had asked, before I move on to the next section, somebody had asked, mentioning putting an enter at your own risk sign. And then does this, along with business maintaining other sorts of regulations, cover a business owner? I think it helps. I don't think it's going to eliminate the risk entirely. It's just going to depend on a lot of different factors. If you are doing enter at your own risk and then you are actually implementing social distancing and making it very clear, about what other requirements are there, then yeah, it's going to help. If you're doing enter at your own risk and then nothing else on the inside, it's not going to matter too much. But there's not kind of one thing you can do to totally eliminate the risk. We can just reduce it. One thing I thought of was whether or not, either with your customers, depending on the type of business that you're running, would you want to do a waiver, a written waiver that you're not responsible. And in certain circumstances, and we can, at a later time could get into more detail, in certain circumstances though, waivers for a business's negligence are enforceable. But, each case again is going to be determined on its own facts. And, was it reasonable for the business to even ask that person to sign a waiver? Things like gyms, you can sign a waiver saying that, we're not going to sue you for some negligence. Now, you cannot waive reckless conduct, or some sort of intentional conduct. I don't know how you would intentionally give someone COVID, but I think recklessness would be more the question, where you're just, it's just a complete disregard of somebody's rights. So, again, a lot of different factors, but, putting up a sign, that indicates entering at your own risk, it's not necessarily going to hurt anything. So I think our third section is where we're coming to with other businesses. Again, this is the liability of one business to another related to COVID-19. These questions are going to fall between, vendors and suppliers. Were you unable to fulfill orders for goods or services, to your other businesses? And I think here the biggest question, like we talked about before, was whether or not the business's performance was made impossible by the pandemic, or whether it was just made impractical. The law says that if we're claiming impossibility, that we basically have to show that we did everything that was in our power to, keep us from breaching our contract. And, so it's not like you have to do everything physically possible or even impossible to do that. But, it's going to be a little more difficult. And the other big issue I think there is whether or not there was the kind of forced stay-at-home order, or, did you shut down voluntarily to try and slow the spread? I think courts are going to be sympathetic to that argument. I mean, I don't know that but as I'm speaking, I think a court, is going to see, okay, well, no, of course you weren't going to be subject to criminal prosecution because you didn't because you shut down or didn't have to or something like that. But if it was reasonable for you to do that because of the line of work you were in, I think there's going to be some more leeway there. Again, these cases are very fact specific, and will turn on a lot of different factors there. So a couple of other scenarios and considerations, some we've talked about, and some are just kind of to be aware of. Again, leave policies, FMLA, are we going to be seeing some some privacy concerns with regards to telework? Failure to support employees when they're trying to work from home. Those are things that we can think about. What about health data of your employees? Again, that's another privacy concern. When, let's say, an employee does get sick and you are trying to, identify where they were at and who they were around, I think the best policy there is going to be to try and keep as much confidential as possible about that person. But certainly something, just to be aware of. We've seen potential to see some whistleblower claims about employers who are not taking precautions, and then employees who raise an alarm for that. Layoffs, federal law requires certain notice for layoffs. We are seeing some claims that employers failed to give the appropriate notice. Consumer claims of price gouging and misrepresentation, we are seeing those, with the PPE and things like that. And then insurance claims. This is something that I didn't get into a lot, but the insurance industry is based upon risk. And so there is potentially a lot to be gained by discussing some of these issues with an insurance provider. Business interruption insurance, but then also defense of, customer or employee claims. You're going to have different types of insurance that cover different aspects of your business. Of course, your workers' comp insurance is going to cover your employees and their workers' comp claims. Your general commercial liability policies, may cover negligence claims by an employee or by a customer. But, again, it's going to depend on, what your policy says. And a good place to start is by reading the policy. If you have some free time and want to do that, or certainly by discussing that with your insurance carrier, you're going to be in a good position, to know what they say, and to be ready for that. So a few other things. Again, many of these issues are fact specific. Liability determinations are very hard to generalize. That's one thing I do consistently, is try to, analogize your case with these, 10 other cases that were similar but not exactly the same. What can we glean from that? How do we, think that a court might rule in this situation? And then always, the big question in the room is it worth pursuing? So those are the sorts of things that we think about. I think be reasonable and be smart. Educate yourself, again, on best practices. You have a great resource in the chamber. Use that. And work with your customers and clients and your other businesses before these issues arise. Try and get with them and resolve these disputes so that you're not having to, think about a lawsuit and defending that. So those are Oh, and there are just some resources for you. Missouri Show Me Strong Recovery Plan, specifically for businesses. There's a great guide on a return to work guide on the Missouri Chamber of Commerce website. Missouri Department of Labor has some information on worker comp and things like that. The CDC has guidance. Of course, the Federal Department of Labor would have guidance on the FCCRA. So all of those things are great to check out. And that is all that I have. So we have a couple of, or one other question, and it says, if a business wants people to wear masks while inside their store, should they put up a sign like no shirt, no shoes, no mask, no service? That's a good question. And I think that, yes, if you are going to mandate the public wearing a mask, then you need to tell them at the earliest possible opportunity. And this is also where, if you have a Facebook page, putting it up on your Facebook page, trying to get that out there as soon as you can. Also giving people an option for if they want to patronize your business, but they don't want to wear a mask, how, you can still make an order. You can still order online. You can order over the phone, make that information very, very visible. I don't see much liability concern in terms of them turning around and suing you for, I'm not sure what cause of action that would be. But it is certainly something to think about in terms of keeping your customers happy and keeping your customers engaged while protecting yourself and your employees. I don't think that's an unreasonable request at this point in time, particularly since, we are one of the earlier states to be sort of opening up. And so, I think it's good if you're going to require that, certainly put up a sign of some kind. Any other questions? Well, I'm happy to answer any. If anybody has any now or later, I'll put my contact information back up on the screen. So it is there. Feel free to email or call anytime. And we are happy to help.
Okay. Well, thank you so much, Jackie, for that information. We have recorded this session, so we will have it available if anybody would like to re-watch it so that they can capture maybe something that they may have missed. Jackie, would you feel comfortable with sending me your presentation so that we could share that as well? Okay.
Absolutely. Yeah.
All right. Thank you. So I hope that you all got something out of today. If you have any questions, you feel free to send those to Jackie, or you can send them to me, and we will do our best to answer that. If you have some other questions that maybe weren't answered today, and there's a webinar that you feel like we need to have for our members so that they can get educated on a specific topic, feel free to send those requests to me or to Justice or Shane, and we will do our best to schedule an event like this. We just are trying to help our business community get educated on the topics of this uncertainty, because we have a lot of businesses that are trying to open back up today or in the coming weeks, and we want to make sure that they have all of the information and resources necessary to do that where it's safe for them and for their customers. And also, as Jackie mentioned, your vendors, people that are servicing you. So thank you for joining us today. Yes.
Oh, we did have one question, and it says, if an agency is exempt from FMLA, does the FCCRA expand the agency's policy, or I guess requirements to offer FMLA? So it says expanded medical leave is in place, and that is a question that I don't know the specific answer to, but I am happy to try and get some information and send it out to you if you'd like, so we can update people. Basically, if you don't otherwise qualify or are required to provide FMLA, do you have to under the new requirements?
Thank you, Jackie. Any other questions or comments before we wrap up here today? Okay. Well, thank you so much for joining us. And don't forget chamber check-in at 1 p.m. today. We'll be sending a link soon. Thanks. Thanks, Jackie.
Thank you.